We're back with our second podcast with Maria de Lancastre Valente from SRS Legal in Portugal. And today we're speaking about the end of employment.
Okay, so I'll kick off, Maria. What protections against dismissal do employees enjoy that employers need to be aware of? What should employers be thinking about when it comes to dismissal?
So I think the main issue surrounds termination of employment. Portuguese employment law is governed by a constitutional principle that establishes that an employer cannot terminate employment unilaterally without just cause. And just cause, and it goes on to explain and to translate this into what it means by just cause, and to the procedures that have to be followed in order for a just cause to operate and for dismissal to operate as a consequence of just cause. So termination is regulated. It's regulated by a mandatory regime that cannot be discarded by employer or employee, albeit by agreement. So regardless of what the parties wish to establish or to stipulate, they cannot do so, even though they're in agreement that they want to waive the termination rules and the termination regime. So I think that's the first main issue regarding dismissal. Dismissal, this idea, this concept of just cause then translates into what we call objective just cause, so economic-based just cause. So termination of employment or dismissal that results from economic reasons, and these economic reasons are listed in the Labour Code. So we're talking about market structural and technological reasons that relate to the company. And then we have subjective just cause that basically is a disciplinary dismissal. Again, in both cases, there are specific procedures with specific thresholds. So the parties aren't free, or the employer in this case is not free to choose the termination regime, for instance, regarding economic-based just cause. Either a collective dismissal or individual termination will be triggered depending on the number of employees, depending on why the termination is being triggered from a company perspective, etc. And then the procedure has to be followed. If the procedure is not followed in accordance with the law, it will constitute unlawful dismissal. So, and the same for disciplinary dismissal. So disciplinary dismissal is a sanction. It's the most serious of a list of sanctions that are established, again, by law. And the employer is not free to create its own dismissal regime. It will have to follow the procedure that is established in the Labour Code. I think another relevant point is to say that poor performance in itself does not constitute just cause for dismissal. And that's an important point, especially for jurisdictions where there is more flexibility surrounding termination. So the idea of termination with notice or summary dismissals, or however you want to call it. These are concepts that do not exist under Portuguese employment law. So anything related to dismissal and termination has to be navigated with caution, because procedures have to be followed, concepts have to be filled in with factual information, business cases have to be built to support certain decisions, and notice periods where they are applicable also have to be followed.
That's very interesting, and clearly quite a number of points of difference with the UK. Just following up on one point, in the UK, employees with over 2 years service have protection against unfair dismissal. So there are limited circumstances in which a termination can be made, and there has to be a fair process. And obviously, we've already heard that that's a very different exercise in Portugal. But in the UK, one of the distinctions relates to compensation. Compensation is broadly capped at a year's salary or around £90,000. But because of that cap in the UK, employees often bring claims for discrimination to maximise their potential compensation. Do you have the same issue around discrimination claims in Portugal, or is it different for you?
It's different, and I think the main reason being because in Portugal you do not have to maximize potential compensation because because there aren't any caps basically. The way an employee will react to an unlawful dismissal will vary depending on the source of that dismissal, but if the dismissal is ruled as an unlawful dismissal, the court will, first of all, the employee has the right to being reinstated, or they can opt for compensation in lieu of reinstatement. That compensation is set between 15 and 45 days base remuneration, plus what we call seniority subsidies per each complete year of service, and a fraction of service is prorated. And then the employee will also be entitled to the salaries he or she stopped receiving since the dismissal date until the court ruling. And when we say to the court ruling, we're saying up to, ultimately, if they appeal to a final court ruling. So it can be quite a long and quite an expensive route for the employer. In addition to that, an employee can also claim damages, and there aren't any caps to the amount of damages an employee can claim. So the concept we have is moral or pecuniary damages. So if they feel that they have been discriminated against, they will use that the concept of damages to perhaps enhance their compensation. But we do not see, I can't identify a trend, although I can identify and the concept of discrimination and particularly harassment has gained relevance within the Portuguese context. I cannot identify a trend that strongly supports the statement that an employee will necessarily bring a discrimination claim to maximize their potential compensation. They may do that, but they would not necessarily have to do that in the first instance to receive compensation.
That's really helpful. And I think that obviously we've been asking similar questions in our other podcasts, and that seems to be the case with other jurisdictions. We seem to be a slight outlier on that our discrimination claims are much more popular here because of the absence of the cap. Yeah. You mentioned earlier, obviously, the subjective just cause and termination for that. Are there circumstances in which an employer can terminate almost immediately for cause? So in the UK, we have the concept of summary dismissal for gross misconduct. Do you have a similar thing?
No, we don't. And so I was going to say the only other way you can terminate immediately will be, so I'm talking about permanent employment contracts. I can then very quickly explain about the term contracts, but you can only necessarily terminate for cause if you want to terminate for gross misconduct. That from a Portuguese employment law perspective will be construed as a disciplinary breach. And in order to carry out that dismissal decision, you have to follow a procedure that involves formally, so drafting and writing a formal accusation. The employee has a right to respond. There are timings. There's an evidence stage, and then the company can take its decision regardless of whether the employee agrees, obviously. But it's not immediate, and it will necessarily not be immediate. So that's, I think, one thing that's very important to underline is that when addressing a potential termination issue, there has to be some time to prepare. And obviously I'm conscious that from a business perspective, that isn't always the answer that the companies want to hear. But because the consequence can be an unlawful dismissal claim, certainly assessing options and weighing risk should be taken into account before any decision is taken and communicated to an employee. The only other way, obviously, in which you can terminate and immediately will be obviously by agreement. In that case, you can terminate with immediate effects. Typically, that will involve paying compensation. And it will involve paying compensation that's higher than the statutory minimum that an employee would receive under a unilateral, so under an economic-based termination scenario. So that's something that also has to be factored in. A company will, when they're approaching termination, will always necessarily have to weigh in time, cost, and risk. So it's within these three variables. If they have more time, perhaps they needn't have to spend so much money, and they'll probably have more time to consider the risks of pursuing a specific route for termination. If they have less time, then in that case, they may have to consider paying more, and risk may be lower, because by obtaining consent, they will be able to waive any potential disputes or claims. So it's within these three variables that typically an employer will have to navigate when approaching dismissal.
That's great. That's really helpful. Thank you. And again, you briefly mentioned this earlier about notice. And so in the UK, separate to the unfair dismissal protection, an employer needs to comply with the contract of employment when terminating an individual's employment. And this usually requires notice to be given, as I think you mentioned that you have the similar concept in Portugal. Mm-hmm. But often the contracts will give an employer the right to place an employee on garden leave or to pay in lieu of that notice. Mm-hmm. Is that something do you have that concept, those concepts in Portugal?
We don't have the concept of garden leave as such. And in relation to the notice periods, there is no freedom to stipulate them contractually in line with this principle that there's a mandatory regime that governs termination that has to be followed. So notice periods will exist when the employer is terminating a contract unilaterally based on economic reasons that can then trigger either a collective dismissal or an individual redundancy. And those notice periods depend on the employee's length of service. So they range between 15 days and 75 days, depending on how long the employee has been with their employer. What in some and disciplinary dismissal, we don't have the concept of notice period. So the employer, once the procedure has been followed, can dismiss. Once the decision of dismissal has been communicated, termination takes effect immediately. Where in relation to garden leave, where those notice periods exist, we have a similar concept. So the concept that we have is one where a company or an employer can temporarily release the employee from his or her obligation to work, and in that case, that should ideally be agreed upon. And I say ideally because under Portuguese employment law, the employee has the right to actual work. So the employer has a duty to ensure that the employee actually works. And so the employer cannot place the employee or tell the employee to go home, even if the employer pays remuneration without justification. What will happen in most cases in practice is under so economic based termination scenarios, if the employee if there's no point in having the employee carrying on to perform their duties, if it doesn't make sense, if their duties are under a phase out, etc., the parties can agree, or the employer can place the employee on this temporary release from the performance of their duties and pay out the remuneration. So that's the way it's sort of built from a legal perspective. It is possible within certain boundaries.
Fantastic. I wanted to just follow on from that to just ask a very specific question about whether there are any groups of employees who have special protection in Portugal against dismissal.
Mm-hmm. Yes, we do. So we have employees who are who are subject to parental rights at the time of their dismissal. In some instances, the employer will be required to notify the Commission for Equality at Work that will make sure that the process or that the dismissal is not attributable to discriminatory reasons. So for certain groups, yes. For certain categories also of employee representatives, so in employee representation structures, there may be the presumption that a dismissal is deemed without just cause. So that is something that also has to be factored in when an employer is approaching termination and of either a single individual or a group of individuals, where there are certain groups of employees, and how that will influence the timing of the process and ultimately their business objectives, especially in the context of reorganizations, and if there are other timings that have to be considered, how that can impact the process and the timing to achieve certain business and operational goals.
That makes sense, and actually you've just touched on something in your last answer that goes to this next question, which is what role works councils or other employee representative bodies have when employers are considering dismissing an employee.
They can intervene. They may be called to intervene where they exist. In some instances, so where a works council exists in an organisation, in a company, or a trade union representation is present in a certain company, these employee representation structures may be called into and have to be notified of a particular process that's going to begin and have a role in negotiation, in a negotiation stage. So I'm thinking of, for instance, a collective dismissal, or they may be called in to issue an opinion under a disciplinary dismissal, or more broadly, in some instances, there may be a duty of information or consultation regarding certain issues, depending on their relevance and depending on what they are. So the Labour Code lists the instances where this is mandatory.
Great. And on to our final question of this this podcast. So what practical steps should employers think about when they're trying to resolve termination disputes in Portugal? So for example, and I think you did touch on this earlier, severance packages in return for waivers of claims under settlement agreements, are they common in Portugal?
Yes, they are. I'd say the practical step is, first of all, just basically just being able to flag that it is a jurisdiction where termination is not immediate, and because employment law and termination of employment is regulated, that procedure will have to be followed, and termination overall has to be navigated with some caution. So if at all possible, when a company is considering termination, it should it should do so with time. So prepare for the termination. Think about the number of employees that are impacted in the short term. If it is a disciplinary issue, try and understand if the disciplinary, if there is an advantage in following a specific procedure, or if it's easier to pursue or explore other termination rules, such as termination by agreement. And also, I think that those three variables that I mentioned, so the time, cost, and risk, the result, it will always depend, I think, on a case-by-case assessment. So it isn't a scenario where for certain groups you would necessarily always follow this route, and for certain other categories or for certain sectors another route. Severance packages and enhanced severance packages are very common because the termination, the unilateral termination rules are regulated. Companies tend to prefer, and I think it's a common trend, to try and settle in the first instance. And that will involve typically a negotiation and trying to understand what an employee would be entitled to under a unilateral scenario that would render the employee eligible to compensation, and then building a severance package that is appealing to the employee and that will persuade the employee to accept termination comfortably. So I think these are the two main issues. There isn't any specific rule surrounding severance packages. I think, and also another practical step, or certainly a practical issue that is relevant, is thinking about culture, and obviously company culture, but also national culture, and the way people approach termination, the way dialogue is handled, the way termination is addressed, because I think that in my experience that sometimes renders termination conversations more difficult, where the cultural idiosyncrasies aren't perhaps considered in the equation. So I think these are the three issues that I would outline.
Perfect. Thank you, Maria. And please join us in the next podcast where we'll be covering other key employment law topics in Portugal.